Thanks so much, Emma. And so finally handing over to Katie Dawson, barrister and member of Lawyers for Choice, who's going to wrap up for us. Thanks, Katie.
Hi. So at this point, I really wish I had a speech because the prospect of actually addressing a group of lawyers about a legal issue is more scary than I thought it was going to be. I would really like to thank the other speakers. I had the pleasure of meeting Amanda's husband last Saturday when I was speaking to an information meeting in New Ross. And I said to him, I really hope that in 2.5 weeks' time, 3 weeks' time, you won't keep having to tell your story this way. I think we have to look at ourselves as a society and ask, what do we want an Ireland of the 21st century to look like? I think for far too long we've been having a very dishonest debate about, well, we've just been having the wrong debate. We've been having a debate about whether abortion is right or wrong. And that is a moral question. I don't think everyone in this room will necessarily agree on it. I don't think everyone in this room will necessarily agree about the circumstances and the cases in which somebody should be able to have a termination. But that is not really the question that we're being asked to address on the 25th of May. Abortion is in Ireland. I know there are posters saying 1 in 5 in the UK and don't bring that to here. That is here. Abortion is here. Abortion was here in 1983. Abortion was here in 1967. Abortion has been here 100 years ago. So the real question we need to ask ourselves is how do we address that issue? And what kind of laws do we want to have? So I think the first thing to be said is that we really do need to remove the 8th Amendment from the Constitution. It does virtually nothing to enhance fetal protection that we couldn't do by legislation, but it does a very great deal of to endanger the lives and the health of women. Whatever its intention, however well intended it was, what it means is that if there is a fetal heartbeat, then the law requires doctors to do everything possible to allow that fetus or that baby to be delivered alive, however long they live, whatever the quality of that life. That is what our law says, that they're to be delivered alive, regardless of the cost to the woman, regardless of the risk to the woman, regardless of all of the circumstances of that pregnancy, unless it's a situation where there is a real and substantial risk to the life of the mother, and the only way that that risk can be avoided is by way of a termination. So that is the law that we are dealing with. As long as there is a fetal heartbeat, doctors cannot give women treatment that they would otherwise receive. And we know that the 8th Amendment has caused huge harm to women. We know that women have died because of the 8th Amendment. We know that in the case of Michelle Hart, when she received a cancer diagnosis, she was not able to receive treatment that she would have been able to receive had she not been pregnant. And that women who find themselves pregnant find themselves in a situation where the ordinary rights they would enjoy as a person are suspended. Their ability to consent to medical treatment is suspended if there is a risk to fetal life. And so we know what happened in the case of Michelle Hart. Doctors weren't able to give her the treatment she would have been able to get had she not been pregnant. We know the tragedies that have come from the 8th Amendment. We have the X case, we have the Y case, we have the A case, the B case, the C case, a couple of D cases, the BP case, the PP case. We're running out of letters of the alphabet in terms of the hard cases that have come before the court. A number of people will talk about the Savita Halappanavar case, and people on the no side will say it wasn't a result of the 8th Amendment, it was as a result of sepsis, it was a result of mismanagement of her case. The reality is that if Savita had been able to get the termination that she had requested, when she first requested it, she would not have developed sepsis. She would be alive and nobody would be talking about her case. And what we have to take from this is to ask ourselves, is this the treatment that we want women to receive in Irish hospitals? In the case of Savita Halappanavar, we know that that was an inevitable miscarriage. It was an inevitable miscarriage. There was nothing that could be done to assist that fetus or protect fetal life. It was an inevitable miscarriage. Had she been given the treatment that she would have been able to receive in virtually every other European country, she would not have developed sepsis. The sepsis she had was the result of, was from the contents of her womb. So her pregnancy literally killed her. And she lay on a hospital bed and she knew the risks. She knew, I think, that she was going to die. And we have to ask ourselves if this is the level of healthcare that we should be providing women in this country. I sometimes say that the Eighth Amendment says that really the only right a woman has who's pregnant is to get out of it the other side alive, whatever the quality of her life. And we know, for example, that there were a number of people for whom pregnancy is a real risk to their health. And we saw it in the case of Michelle Hart. Also women that might go blind if they continue their pregnancy, that might go have organ failure if they continue their pregnancy. We can't do anything to help any of those women unless we remove the eighth from the Constitution. And we know that even getting out the other side of the pregnancy alive, even not getting out the other side of the pregnancy alive doesn't mean that you're spared from the Eighth Amendment, because we have the horrific case of PP, and that was a case where a 25-year-old woman who in fact had 2 kids was clinically dead, was brain dead, and she was being kept on life support machine because there was a fetal heartbeat, and her father and her partner wished to turn off that machine. But the doctors, the HSE in that case, said, look, we can't do that because there's a fetal heartbeat. We're afraid to intervene. And people may judge doctors in that situation, but I don't envy any doctor that finds themselves in that situation. If you perform a termination outside of, now I suppose that's a 2012 case, so it predates the Protection of Life During Pregnancy Act, but if you perform an abortion or a termination outside of the legal remit, it is a criminal offence. It carries a sentence of up to 14 years in jail. So doctors in that situation are absolutely going to be frightened to act or to do something which may lead to a criminal sanction or finding themselves before the Medical Council. So that case came before the court, the High Court, in December 2014. And the circumstance, the facts of that case are quite grim. She was literally decaying in the bed. They were putting makeup on her to try and spare her kids the upset of seeing her. Her skin was falling off. And there was overwhelming medical evidence that there was no prospect that this fetus could be brought to the stage where it would be viable. So even in the situation of a brain dead woman, even in those horrific circumstances, the fact that there is a fetal heartbeat led to doctors feeling that they couldn't act. I could go on about so many of the cases and the degree to which the Eighth Amendment harms women. It's important to remember as well that the Eighth Amendment applies to all pregnant women. It doesn't just apply in cases of abortion, and we see that from the BB case. That is a case, and I remember talking about it in Ross on Saturday, and people just looking at me like that couldn't possibly be true, or that couldn't have happened. And that was a case again where you're dealing with a wanted pregnancy, very much wanted, and there was a disagreement about how that pregnancy would be managed and how the baby would be delivered, and the mother had a different view to the medical staff. And a colleague of ours, actually, Wendy Lyon, was involved in that case. I don't know if she's here, and she'd be far better to speak to it than me. But just very briefly, the HSE went to court and looked for orders, extraordinary orders in that case, on the basis of a risk to the life of the fetus. Orders that they would be able to perform a caesarean against her will. Orders that they would be able to take bloods against her will, perform ECG and other medical tests against her will, orders that they would be able to use reasonable force to restrain her to perform the medical treatment they believed, an order that the Gardaí could arrest her without warrant if she left the hospital, to return her to the hospital so that they could perform the medical treatment, and in order that she couldn't have somebody she wanted to have support her in the birth present at the hospital. So an extraordinary range of orders that just simply would never arise in ordinary terms in terms of a person's medical treatment. Now, the judge in that case didn't grant them the orders because the judge was satisfied that there wasn't a serious risk to the life of the fetus. But in a different set of facts, could those orders be made? In a different set of facts to the PP, if the fetus was a little bit further along the way and there wasn't a consensus that there was no prospect of this fetus surviving, could that woman be kept alive on life support machine while she decayed? I would like to be able to say no, but unfortunately I can't. I'm going to finish up in a little bit and answer any questions anybody has. But today I was re-watching the debate that took place on Today Tonight between Mary Robinson and William Binchy, and I was struck by how Mary Robinson was saying, look, this wording is really problematic. As lawyers, we really can't say for certain how it's going to be interpreted, and really the amount of legal uncertainty. And on the other hand, William Binchy just very doggedly saying the law is absolutely clear, was absolutely certain, saying we would never have a case where an injunction would be sought to to prevent a woman from travelling, which are literally the facts of the X case, and just saying with absolute certainty that the Eighth Amendment, would protect women. And we know from what Peter Sutherland said in his advices at the time, and he advised that the wording as was proposed and was inserted was really problematic, and in fact that there was no wording that would achieve what the pro-life side were purporting to want to achieve, and that the wording that was there was just going to end up, first there was a risk that it would end up making abortion legal under Irish law, which is in fact what we know happened with the X case, because the Supreme Court read into Article 43.3 that there was a right to have an abortion if there was a real and substantial risk to your life, and that could only be avoided by way of a termination. And lawyers at the time said, look, this is really a problem. We're just going to end up with a lot of hard cases before the court. And unfortunately, the subsequent 34 years, I can't add very well, but I think it's 34 years, has proven that to be correct. And I really hope that I won't have to continue to make speeches like this or to go to meetings around the country, and I can get back to doing Simpson quotes on Twitter, but unless we remove this from the Constitution, we cannot legislate for cases of fatal fetal abnormality. We cannot legislate for cases of rape or incest. We cannot legislate to allow women to have not unrestricted abortion, because that's not what's being proposed under the heads of bill. What's being proposed is quite a conservative measure that up until 12 weeks you would be allowed to have an abortion medically supervised. So you go to your doctor, they certify the period of gestation, you're given advices, you go away, and you have 72 hours to think about it, and you come back, and then you're allowed to have an abortion. After 12 weeks, it will be illegal except for 3 exceptional circumstances: the cases of fatal fetal abnormality, and that is where the baby, very much wanted pregnancies, the baby will either die shortly before or after birth. Cases where there is a risk to life of the mother, and cases where there is a serious risk to the health of the mother, and that will have to be signed off by 2 doctors, one of whom is an obstetrician. So a very conservative proposal, but it isn't unrestricted, and it is a way to try and deal with the reality that we already have. So what kind of society do we want to have? Do we want to have a society that says to a 15-year-old girl who's in her room, you go and get the abortion pill online, you take it in an unmedically supervised way, you take it in circumstances where if something does go wrong, you're afraid to go to the hospital, you're afraid to go to a doctor because this is a criminal offence? Or do we want a society where we say to women, we are not going to judge you, we're not going to control you, we are going to trust you, and we are going to support you? The abortion pill, for example, is very safe, but I have learnt, and I only learnt this myself last week, and I'm learning something new from everybody that I talk to about this, but that if you take the abortion pill after 14 weeks, it actually can be seriously damaging to your health. So if you don't know how pregnant you are, you may take that pill believing you're only 8 or 9 weeks pregnant, you're actually 15 or 16 weeks pregnant, and it poses a serious risk to your health. So I think we need to move away from a discussion about whether we personally think abortion is right or wrong, and move to the discussion, abortion is here, abortion is happening. So do we want it to be a case where women can access legal, medically supervised abortions, or are we going to turn our backs on these women and allow them to muddle on as they've done to date? And Lawyers for Choice definitely believe that we should repeal the 8th Amendment and allow women to access medically supervised abortions in Ireland.
Great. Well, I hope you feel that, having heard from the range of expertise we have in the room, that you'll be ready to join up with those canvasses. I know lots of you are doing a lot already. So we would just encourage you to engage with the legal resources that are available. Use abouttheeighth.com, sign up for, with Catherine there, sign up for Together for Yes, Lawyers Together for Yes, and there's lots of different ways in which we can really just progress that legal conversation now, make repeal the 8th happen, but also arm people to think about what needs to come afterwards. So I think what we'll do now is we'll encourage maybe informal conversation. Our speakers are available to answer questions, and we'll circulate a little bit, and we'd encourage you to engage with members for Lawyers for Choice, and any comments or questions that people have, we'll do that informally. Okay?
Also encourage all of your friends to sign up for Together
For Yes.
The lawyers for Yes on the Together for Yes website. All your friends, not just yourself.
And yes, lots of great free resources. So take your leaflets and a donation for your badges. Okay, thanks everybody.
Thank you.